Good evening and welcome to the Drive at 5 on the IntellectualRadio.com/iHeart radio station. I'm your host, Roman. We have a great show planned for you today, but first, the forecast from our IntellectualRadio.com Weather Center. Today, mostly sunny and very warm, high 88 degrees. Tonight, partly cloudy and warm, low 70 degrees. Tomorrow, to partly cloudy, humid and remaining warm, high 87 degrees. Tomorrow night, you're shaking your head over there, mostly cloudy and warm, low 64 degrees. Now, Wednesday is a different story. Wednesday is cooler with some sun, high 71 degrees. On Thursday, turning sunny and nice, high 72 degrees. And on Friday, sunshine and patchy clouds with a shower in the area in the afternoon, high 67 degrees. The Drive at 5 is also part of the new Monday night lineup with acreage, assets, and acquisition / policy matters with your girl Rhea Ray Harris at 6 p.m. New Black Leadership is at 7. 9 p.m. is the Chronicles of Ron, and the Mic Up is at 10 p.m. Also, the Drive at 5 is also part of the fabulous 5 at 5, only on IntellectualRadio.com. We also have some breaking news according to the media reports that's out there. We want to share with you that Korean President Kim Jong-il declared war on the United States and Donald Trump. Keep your ears glued to the television. You're here on IntellectualRadio.com. A lot of people are worried about that. We will have other shows and other hosts discussing the matter of what's going on coming up real soon. But again, breaking news, we have Kim Jong-il declaring war on the United States and Donald. Please stay tuned to Intellectual Radio for more details coming up real soon. My guest is from the Chicago Legal Clinic. Please give a Drive at 5 welcome to Attorney Adam Salzman. How you doing today?
I'm very well. Thank you, Roman. I'm so happy to be here. Thank you for having me.
Please give IntellectualRadio.com/iHeart radio station the background of Chicago.
So Chicago Legal Clinic is an organization with a really rich history. We go back going on 37 years now in Chicago. It was first started by a parish priest from the Catholic Church and a young attorney just out of law school. The priest was a lawyer too. They met in law school. So it's actually a beautiful sort of interfaith origin story. A young Jewish attorney and a young Catholic priest started this organization in the South Chicago neighborhood down on East 91st Street, where we still have an office. And the organization was started in response to the closure of the steel mills in the area, which created a real need for low-cost social services of any kind and legal services in particular. So it started as a small storefront legal clinic geared toward people who would not otherwise be able to afford legal representation. And over the course of the 1980s and into the 1990s, the people that the organization served grew, and the number of practice areas that the organization engaged in grew, so that they developed an immigration practice and opened another office in the Pilsen neighborhood, developed a family law practice and opened an office in the Austin neighborhood. We still have both of those offices, and then eventually opened up an office in the downtown area. We have an office in the Loop too. And Chicago Legal Clinic, in essence, it provides low cost and no cost legal services to people who would otherwise not be able to afford quality legal representation. And our mission is to increase access to justice for all Chicagoans, regardless of income level or background.
Now, with saying that, your specialty, blank slate.
an important one of our that's an important program that we have that focuses particularly on folks who might have a criminal record, being able to seal that record or expunge that record in order to move forward and not have that record interfere with their employment prospects.
Now, please explain blank slate for ex-offenders, and why is it important to have a blank slate instead of, is there a difference between the two?
Well, so there are two different ways of going at it if you happen to have a criminal record in your background, depending on the severity of the record. But you could pursue an expungement, which means that it's in essence stricken from the record, and it's as though it never happened. Or you could have what's called a sealing, which is that the record continues to exist, but people can't see it. That's it. Either way, if you're able to move forward with a job application and not have to disclose that record, it greatly enhances your employment prospects. So both are worth pursuing. Expungement is a more complete cleaning, if you will, of your record than a sealing, but either can be tremendously helpful. And as I am saying this right now, the person who started the program is walking in the door, and the person who currently administers the program is walking
let
in
me
the door.
introduce. We have Marjorie Nielsen of the Chicago Legal Clinic, and Drew Curley, right? Drew, have a seat right here. And Marjorie, have a seat right over there. We're talking about the blank slate and the difference between a blank slate and expungement. Could you, and I'm sorry, I know you need to settle, but.
Yeah, thank you for having us. Appreciate it. And sorry for being late arriving here. If
I could just interject, guys, I think the distinction we're talking about is between sealing and expungement, and you could also talk a little bit more about the venue in which that can be done.
Okay. So the shorthand difference between expungement and sealing is that a enforcement retains a copy of it, and an expunged record, they do not. For public consumption purposes, so for like background checks, a sealed record and an expunged record will show the same way, which is to say it won't show. But if it's sealed, unlike with expungement, law enforcement still keeps it. So if you were applying to work with law enforcement, they could still see that record. And if you were to be arrested again, law enforcement would have access to those sealed records, and so could take those into account. I want to say that's the simple version of the difference between expungement and sealing.
And the sealing is a blank slate, or?
So blank slate is the name of the entire program under which we provide those services. So we call it the blank slate, but the different services under that heading are expungement and sealing.
Now, what is the process in order to get a blank slate? You walk us through that?
No problem. So the goal at the end of it, and we named it blank slate, because the goal is to get people back to a blank slate as far as what their criminal record says. So something that's empty and doesn't have previous arrests or conviction records on it. The process for getting there, it depends on your case type, but for our point of view, contact us and we will evaluate your record. We prefer for people when they contact us if they can bring in a copy of their Chicago rap sheet, or if they don't have a Chicago case, their Illinois State Police rap sheet. And the reason for that is so we can see all the different arrests and convictions in the background, and also that those are required to be included in any petition you do. So you contact us, you send that in, we review it, we see what relief you're eligible for, whether it be expungement or sealing, and we prepare a petition that we then submit to the court, asking for the most relief that's available. So if you're eligible for expungement, generally speaking, we'll always ask for expungement. If a case has to be sealed, we'll ask for it to be sealed. Your petition with us, you'll get a court date set. We'll show up on that court date, and hopefully there's no objection from the either Illinois State Police or Cook County State's Attorney, in which case your petition will be granted and you don't have to do anything else. If for some reason there is an objection from somebody, then we'll prepare for a hearing and let our client know, and they can get ready for it. But it's a court process, so after you've submitted the petition, the judge is the one who makes the final decision. It's not automatic. Even if you qualify according to the statute, the judge is still the one who makes the final call about whether to grant the petition to expunge or seal. Majority of cases do tend to be granted once they're submitted. And in fact, it's actually somewhat unusual to even have a contested hearing. Often there's no objection in the case, and so then we'll just give you your copy or order, and you're good to go.
And eligibility,
Yeah.
That's what you meant. What eligibility? A lot of people say, hey, 7 years, I didn't do anything wrong, and no expungement. Can you explain the process of eligibility?
Yes, and so that's a good question, because that has actually changed quite a bit in this, actually just like past month, essentially.
Can you identify those changes?
Yes. So historically, there were only a very limited subset of case types that were eligible to be sealed. And now it was signed into a new bill that was signed into law by the governor that has greatly expanded the number of sealing eligible convictions. So to back up a moment, generally speaking, exceptions, if you have a non-conviction that's eligible for expungement, if you have a conviction that is only potentially eligible for sealing. And it used to be that only a few convictions were sealable, and everything else, all other conviction types, were just stuck on your background, apart from a pardon from the governor. There's nothing the judge could do about it. Now, starting with this new law, there's instead only a handful of case types that are not eligible, and everything else is. So in some ways, the presumption, if you want to call it that, is kind of flipped. And it used to be we'd tell people if it was a conviction, probably you're stuck with it unless you got clemency. Now, if you have a conviction, most likely it is eligible unless you have one of the special types of convictions that are not eligible. And actually, I think that could be a good thing. You can tag Margie, and she can talk a little bit about the new law and kind of the change that made as far as which cases are and are not eligible to be sealed now.
So the cases that are not eligible to be sealed are domestic battery, violation of an order of protection, DUI and related offenses, sex offenses, and then anything that would subject you to being registering on like either the arson registry or the kidnapping registry or the homicide registry. So there are a number of very serious felonies that do come with registration requirements. But for the most part, once people have passed the end of their sentence and waited the required number of years, they will be eligible unless it's sex offense, domestic battery, or a DUI.
What if a person, you have a lot of cases now here in Cook County, wrongly accused of murder, that expunged?
So there are two ways, and actually one of them is new and is going to be taking effect January 1st, and that is called immediate sealing, which means that if the person is found not guilty, or they have a dismissal based on the state's motion because they weren't able to produce the evidence, and the defense attorney is prepared, they can have that case sealed that very day, the day that the disposition is entered. So that means you don't have to file a petition, you don't have to wait essentially the 6 months. Now, if you want to go through an expungement process, you go through exactly what Drew already said. So whether your case was dismissed or you were found not guilty, if you want an expungement, your petition, you have a court date, there's a chance for an objection, you answer that objection if there is one, and then you get a resolution.
And so just to briefly go into that, the advantage of this new immediate sealing law is it allows for a dismissal or a finding of not guilty to be immediately sealed from the public view on the very same day that you're found not guilty or your case is dismissed. It used to be that you, no matter what, would have to file a separate expungement case, and for that whole period of time, while you're waiting for the expungement court date to come around, so now you can actually get it sealed, and maybe that's enough for you, or if you want to get it completely expunged from your record, so not even law enforcement has it, then you can file a separate petition to expunge. But in the meanwhile, the public can't see it. And that's a big benefit to a lot of people who, might otherwise have, as your question said, a very serious looking charge that they didn't do, sitting out there while you're waiting for the court process to take place.
Let's say I'm an ex-offender. Majority of my crimes that I have committed on my record are drug crimes and drug trafficking. I have not been in trouble for the past, at least, let's say 10 years. No jobs are going to hire me because my past is showing up on my background. What should I do? But I haven't been in trouble for the past 10 years.
So I would say you can contact us about doing a petition to expunge and also seal your records. And it, again, depends on the specifics of which cases, but we would prepare a petition for both. So if you have some convictions, those will have to be sealed most likely. Exceptions, and we'll prepare the sealing petition. If you have dismissals or findings of not guilty, generally speaking, those are going to be expungible. So we'll prepare both of those for you, submit it, get your court date. If you don't have any arrests in the past 10 years, you're going to be in excellent shape as far as the likelihood that anyone's going to object to that petition. Often with a history of drug cases, there are specific case types that require a clean drug test to be included with your petition. When it requires it, if there's a drug history, a lot of times we like to have those ready because the judge asks for it. So that can be another step that we would work with a client about as far as getting ready for that. So prepare a petition, get a clean drug test, include a copy of that result in the petition. And as I said, I think there's an excellent chance that the state wouldn't even object and you would just be granted on the first court date. Or if they do, for hearing and maybe, bring in some other character witnesses. For instance, it's common for our clients, if they're in AA or NA still, to bring in their sponsor or sponsees, other things like that that show, a history of changed behavior, people who know you now and can say, the different life than you were back then.
You wanted to add, Marge?
Yes, there's also another law that's taking effect January 1st, 2018, that is really adding protections for people with criminal records who are applying for professional licensing. So, for example, if you do achieve expungement or sealing, now the licensing boards are not even able to ask about those records. In the past, it was kind of a gray area where maybe they were considered law enforcement, maybe they weren't, maybe they saw your records, maybe they didn't. But this law makes it very clear that if you have expungement or sealing, they cannot ask for it, and they have to warn people that they don't have to disclose that on their licensing applications. So not only is the general public not seeing it, but now the individuals in charge of providing licenses don't see it. And then for people who are not eligible for expungement or sealing but do have a criminal conviction, there's additional protections because now you cannot be denied a professional license without having the opportunity to provide positive evidence of a change in your life and character recommendations and so forth.
Let's say been caught with a small amount of marijuana in the past, and Illinois state law passed the law that states if you get caught with a small amount of marijuana, reduced to a fine, not go to jail, so forth and so on. Now, an individual got caught with a small amount of marijuana. Now the law changed. In the past, in the present, they passed the law to say do away with it to get that expunged. You guys negotiating an answer, right?
We're negotiating who's going to answer. You go.
Okay. So outcome of the case, if the final outcome was a dismissal, which often with cannabis possession charges, often the state chooses not to prosecute it. If it's a dismissal or a finding of not guilty, then you can expunge it and you'll have if it was a first offender probation, which is another common thing that comes up on cannabis or other types of possession charges, you might get what sometimes is called task probation or drug offender probation, other things like that, a qualified probation. That is one of the unusual circumstances I mentioned before where even though it's a conviction, it's actually eligible to be expunged, provided you successfully pass that probation, the waiting period passes, and then you include a clean drug test with your petition. So that is one of the circumstances that what you're asking about, where even if it was a conviction, potentially you can get that record expunged outright. Worst case,
even if years ago, since the law passed, I can get it expunged.
If it was a qualified probation completed successfully, then yes, or if it was a dismissal. Worst case scenario is if you got some other type of conviction that wasn't a first offender probation, in which case it might not be expungible, but it would still be sealable. And again, the sealing and expungement work the same way, because for background checks, which is often what people want to get their record cleared for, a sealing will have the same effect. So even if you didn't get the right type of probation or didn't complete it, satisfactorily, you could still get that record sealed for sure.
No.
What about crack cocaine or any hard type of drugs that was less than an ounce? You will do legally to get a blank slate if it was less than an ounce.
This was so much more complicated before August 24th of 2017, because these questions that you're asking so much, and we used to spend hours going through people's rep sheets and looking at, was it this type of drug case, was it that, and now it doesn't even matter. If it was over a gram, under a gram, you're still eligible for sealing even if it's a conviction. That's the exciting part about what changed, is that almost everybody who has a drug offense, if it's just a straight drug offense, is going to be eligible for sealing. The only reason that they wouldn't be eligible would be if there was some sort of, crime of violence or sex offense that was part of the same case. So Cook County doesn't break out charges. Had a sex offense as charge 1 and dealing as charge 2, even though, the delivery charge would normally be sealable if it's part of a sex offense case. It's not. But now we don't even have to parse the amounts or the types of drugs. It's just everybody has the opportunity for sealing as long as they can show that they've changed their lives.
Even if a past history of, let's say, crack trafficking or something like that, in the past 5 years or 10 years, they can wipe that clean. That's what you're saying.
So I think this is what Drew said earlier that's super key, is that nobody is guaranteed expungement or sealing. Everybody has to demonstrate to the judge that they're worthy of that opportunity. So somebody who trafficked, who can show a remarkable transformation in their life, will have the opportunity to have that record sealed, assuming it's not a federal offense. That doesn't count for this conversation. But the thing is that people have an expectation that as long as they're eligible, they have to be granted, and that's not true. And that really makes judges upset when people assume that they have to be granted the relief that they're asking for. So the more serious your background was, you need to work to demonstrate that you've changed your life. I think that would be a good rule of thumb. If you've got a real serious trafficking background, you're going to have done some really positive things in the community to convince the judge to give you that chance. If you had a, disorderly conduct misdemeanor, you probably don't have to justify getting sealing at all.
And the other thing I would add to that is the length of time since the last time you were arrested matters quite a bit. So if you have a long trafficking history, but that's from, say, the 80s and the early 90s, or even like the late 90s at this point, because we're getting to be, the late teens here. But if it was 20 or 30 years ago, and you haven't been arrested since then, the judge is probably going to look more favorably on your petition, because it's been a long time, and you can show pretty clearly just by the passage of years that, things have changed for you. Most likely you're going to have, a story you can tell as well about, what it was that prompted that change. Whereas on the other hand, if you have a more serious trafficking background and the most recent arrest was last year or last month, you're going to have a harder time then, because the judge is going to be wondering, is this really your past, or is it something you're still doing right now? The other factor is the seriousness of it, and then also the time since it occurred.
Now, what if Illinois law changes a law or a lesser penalty? Should Illinois wipe the slate clean of all people who lies of that particular offense? If the law change in Illinois, and it was like a misdemeanor, now it's a lesser penalty or something like that, should they be arrested for that charge, like harsher, and now it's lessened? What should they do? Should it be wiped?
I mean, we think so, but there's still a process, unfortunately, that people have to go through. So as an example, there was a Supreme Court case that found that the statute under which people were prosecuted for a felony gun charge was unconstitutional, and that all those people had to be recharged as misdemeanor offenders. But you still had to go to court and draw your case to the judge's attention to get it reduced to a misdemeanor, and then you still had to go to court to get it sealed. So unfortunately, Illinois hasn't, taken quite that many steps forward so that these sorts of things are done automatically. But it's definitely something that a judge is going to look at and take into account. So if you have a case that is now considered a misdemeanor, even if it was a Class 1 felony in the past, the judge is not going to just look at the fact that this was a Class 1 felony in judging its seriousness. The judge is going to look at the history and the fact that fine only or something like that.
And the other thing I'd add is, this is another area where the recent change in law in August makes a big impact, because it used to be it mattered quite a bit whether or not your drug offense was a Class 4 felony or a Class 3, or was it a misdemeanor or a felony. Now, with the new law, all of those things are billable the same way. So it's no longer, as Margie was talking about, a matter of counting ounces and charges. So you might have a Class 2 felony that before, you were left without any judicial recourse. Now, it doesn't matter if that was a Class 2 or a misdemeanor now. Either way, it's sealable. And so that is a big benefit for a lot of people now that suddenly have relief that did not have it before.
On to police brutality is a major issue in the African American community. Traffic stops equals harassment. If a young African American male is being stopped by police, what is the first thing he or she should do legally if they feel their rights have been violated? You
sure.
On down.
Yeah, so all three of us here are attorneys, and the clinic that does not do criminal defense work. So I'll just pull that out there as a general matter. That said, I think we could probably all give our version of this. If you are stopped by an officer, obviously the first thing you want to do is comply. You don't want to run. You want to clarify as to whether or not you're under arrest. You want to make sure that you operate in accordance with what the officer is asking you to do and not give the officer any kind of pretext for taking any further action. Guarantee that something won't go awry? No, not necessarily. But one of the things, and I know you know this about me, Roman, is in my former life, I worked for Cook County Commissioner Richard Boykin, and we represented, and Commissioner Boykin still represents a district that has seen its fair share of issues like this. And we worked to create and distribute resources for people to be able to consult in advance so that they knew what to do when these kinds of things happened, understood what their rights were under the Fourth Amendment of the United States Constitution, and also understood the practical aspect of trying not to escalate the situation, but still clarifying whether or not you are in fact under arrest, and making sure that you approach the situation in a way that's rational and that has the best possible chance of preserving the safety and security of everybody involved.
So I would like to add something here actually for kind of the next stage in the process. So if you're, say, in the police station, you got arrested and you're being, held there, Adam mentioned that we don't do criminal defense work, and so that's not an area that you'd contact us, but there is another legal aid organization here in Chicago that is specifically targeted for that scenario. It's called First Defense Legal Aid. They have a hotline, I'm going to give the number in a second, that's open 24 hours a day. People can call in and get a lawyer to show up, give them advice for how to interact with the police in the station, free of charge, completely free. And you can call them. These are people that are specialists. They've been trained for this exact scenario. Attorneys have been. and can help you out. So to give the number real quick is 1-800-529-7374. Again, 800-529-7374. That's First Defense Legal Aid. So that's not us, but it's another good agency that does excellent work in that kind of scenario for helping people out, get an attorney who don't otherwise have an attorney, so that they can handle, being booked in the police station.
They also have really great Know Your Rights cards that you can keep in your wallet that basically just tells you what to say if you're stopped by the police, and they have them in multiple languages. So in case there's going to be an error, you can show it to the police. But basically, don't talk to the police. Be polite, obviously, but don't answer questions. Say you want a lawyer. Give them the phone number to call this agency.
What if the police cover their badge number? There's a lot of cases, you guys are shaking your head, in regards of badge numbers. That's a specific thing that's been going on lately with a traffic stop. They cover their badge, or they'll just do something with their clothing to make sure their badge is covered up so you won't identify the police officer who say this question: should there be a law in Illinois if an individual requests their badge number to an officer, should it be required to give it to them?
Well, I think it should, and I think there's also an additional layer of documentation that the police department now internally requires in every police stop situation, and that was as a result of action that was undertaken by the local chapter of the ACLU. So certainly, a police's officer's badge number should be a part of that. I mean, it should be required, and every stop should be documented, and every stop should be what we refer to as FOIAble. So FOIA, Freedom of Information Act. You should be able to request a record of that stop. And I've seen, absolutely any sort of activity that's intended to conceal and restrict documentation of a stop of a citizen is improper.
Now, yeah, police cameras supposed to be on at all times while on duty. However, some Chicago Police Department officers do not turn their cameras on. A police shooting and an officer does not turn their cameras on, what should be the penalty for the officer for not complying to orders? To remind everyone, these are orders, a law in the books. Your response?
Well, in terms of how the police officer handles, or the police department handles it internally, there are now police review entities that, and always have been, but there are additional police oversight mechanisms in the aftermath of the Laquan McDonald case that have been put in place to ensure that officers follow all necessary procedures to document and disclose what took place. To the extent an officer obstructs that, an officer should be disciplined.
Well, it's not on, should it be on the books that if you're on duty, we know what she said, he said, what you said, what actions took place. There's no questions, ever. Should it be a city law?
Well, yes. I think anything that enhances and increases transparency of those kinds of situations should be state law. You might have additional insight into that.
Yeah, so I would just say, as a matter of kind of personal opinion, and what a good policy for this would be, is that there should be a serious penalty for a time when you have your body camera off. I don't know exactly what that should be, but talking, again, there's a scenario not where it malfunctions or something went wrong, although people with fake malfunctions can be an issue too. But if it was something where it was just on or off and the officer chose to have it off, and then, shooting, God forbid, or something else serious happens, there should be in my opinion, fairly serious penalty for that police officer, regardless of the outcome of the internal affairs investigation into whether the shooting was justified, et cetera. There should be a separate penalty, I think, for the police officer just for having the camera off. And the reason being that would incentivize officers to keep their camera on at all times, because they know just by virtue of having it off that they're going to get in real trouble. That'll keep it on. Whereas right now, I kind of get the impression that if it's off, it's kind of too bad, and so officers don't always want to have it on. I just think that people respond to incentives, and that would be an incentive to make sure your camera is always on at all times, and kind of gets rid of some of the stuff where officers might be choosing to turn it off, which I don't know, if that happens. I can't say every single time, but that seems like it's a concern that comes up quite a bit, and that could be a way to address it, on a more systematic level, as opposed to just, trying to figure out what happened in each case.
Chicago law individual not to record video making an arrest of a suspect. Some people have been arrested or even threatened to be arrested for recording a police officer making an arrest. What should an individual do if they are arrested for recording a police officer making?
I think they should talk to their alderman.
Yeah, I mean, is this a Chicago ordinance? Because to be perfectly frank,
yes, it is.
So, I mean, I think that's probably something that should be subject to challenge. I think that anybody who's doing anything in full view of the public, in public, is subject to whatever. Any one of us who's walking down the street in this particular society that we live in could be filmed at any time. And frequently, I mean, we get filmed without our knowledge when we run a red light sometimes. So I think it's only fair that it should run the other way, particularly with respect to a profession that is under, rightfully so, yeah.
I mean, I would just add, I don't know about Chicago, but there are other jurisdictions throughout the country where people, there've been court rulings that said the arrests when they occur. So Chicago might have an ordinance that says that you can't do that, but there are other places where you could. And to me, that seems, as Adam was saying, that's good policy to make it allowable.
Mm-hmm. Marjorie, you want to add?
I think that if you're in the situation and you're filming from a distance, that's one thing, but we all have heard of all of the horrible consequences of people reaching for something and there being a mistake made. So if you're close to the officer, I would say don't ever risk reaching into a pocket for any reason. Like that, I think is a terrifying possibility that people would feel like they're doing the right thing by recording, this incident, and then, end up being harmed because the officer was them reaching for something. But I absolutely agree that it's something that should be brought to the attention of your alderman, possibly to the local chapter of the ACLU or someone who can challenge it. Because, I mean, Chicago ordinance has been struck down before by the court or have been changed. And I definitely think that it's something where you should have a right to record as long as you're not zone where there's, a feeling that you might be threatening somebody by reaching.
Let's move on to child support. How?
Sorry, we both do family law.
Oh, okay.
That's something that we can speak about, or they can speak about anyway, with a little bit more authority, I think.
How can a man beat a child support case or cases not theirs?
So I'll take this to start with. There's a very important first step in any type of paternity case. So if this is a scenario where you're not married to the mother of the child, if you're married, there's a presumption the child is yours, which you could challenge in court. But if you're not married, then often what happens when the child is born is you're presented with what's called a voluntary acknowledgement of paternity, which is a form that you can sign in the hospital. You'll typically be given it if you're in the hospital and the child is born by a nurse or a doctor. And that form, like it's, to have your name on the birth certificate, be named the father of the child. True. But the other thing that a voluntary acknowledgement of paternity, also called a VAP, the other thing a VAP does is waive your right to a DNA test for that child. And so if you sign that and then 60 days pass, then you've waived your right to do a DNA test. Legally, you're the father of that child, even if biologically that turns out not to be the case. And so my advice to anybody out there is, when you're presented with that VAP in the hospital, unless you are 100% sure that child is yours, don't sign it. And
let me interrupt you there. Don't know.
Right. And that's
and they don't know the process.
Yep.
And that brings me to my other question, because it relates to what you're saying. In the state of Illinois, a person has approximately 24 hours to request a DNA test legally, correct? As soon as the baby is born. However, most men do not know that law, and women are keeping the male away from the room because hospital rules states that if she doesn't want you there,
you're not gonna be there.
She's not going to be there. So if she's saying this is yours, you in that room, when the papers are presented, what if somebody forged?
If it was a forged scenario, so what I was talking about is the broad scenario of you chose to send a VAP, and I guess my point with that is a dangerous thing to do, and so be cautious about it. Maybe if you're in the spot, say something like, "Oh, we'll worry about that later." If it's a scenario where your signature was forged on the document, that is actually one of the things that is a 60-day bar. So normally when you sign a VAP, it's effective within 60 days unless you rescind it within that 60-day window. If if it's a fraud scenario like that, you could go in and challenge that VAP after the fact at any point by going into court. And so there are, this is a plug for the clinic, we actually have a child support and paternity advice desk located inside the Daly Center here in Chicago, where we have attorneys that work at that desk that specialize in paternity cases. And one of the kind of subspecialties of paternity and child support that they have is exactly what you're talking about, which is a fraud scenario where someone forged a signature on a VAP. They successfully challenged that in court and got that VAP wiped out so that it is not there. And then from there you can do a DNA test, prove whether or not you're the father, and if you're not, you're going to be off the hook.
24 hours.
It is not.
It's not. It's what, 48?
You don't sign the voluntary acknowledgement of paternity.
But guys don't know that.
Right.
That's what I'm saying.
Right.
I mean, how you guys get that information out there? If somebody say, here, Roman, you're the father, I'm signing, and you're saying, whoa. Now, if a guy says that, well, let me make sure, what you think the woman's going to do?
Mm-hmm.
I mean, you're agreeing.
Yeah, we totally agree. So we have a family law Q&A that we do every Tuesday at the Daly Center in the Chicago Legal Clinic, and the attorney who helps us with that, who started the question and answer session, his suggestion, and he has been in the hospital for some of his children's births. His suggestion is you stop the nurse before they get to the room with the clipboard, and you say forms about the birth certificate. Now, I don't know if that's going to work, but that's maybe a way to head it off, because otherwise I totally agree with you. The guy is in this really difficult emotional situation. The nurse is now presenting an emotionally fraught mother with, he's saying he doesn't want to sign it and there's going to be an explosion, but it's 60 days. So even if he feels like he's got to sign that form that day, and he calms down and he thinks about it, he has 60 days, not 24 hours or 48 hours, to decide he wants a DNA test, he wants to rescind that.
Yeah, and so anytime within that 60 days, you can rescind your VAP, and then you're no longer legally the father, and so then you can do a DNA test.
Why do women get scot-free?
Oh boy.
I'm what? Why they get scot-free? The name document. Why is she walking scot-free? She's blaming an individual on somebody that is not. Should our law change in the state of Illinois regarding child support? Currently in Cook County, there are guys out there, that's not my baby, that's not my baby. Why should I pay for something that's not mine? Like you said before, hey, you're stuck.
There are a lot of issues with the child support law, especially administrative child support and how that gets handled in Illinois. But to go back to what if the woman lies, subject to perjury, it is a class 4 felony. The problem is that there is overworked, number of cases in the Cook County State's Attorney's Office that the likelihood that she will get prosecuted for the perjury, that's very small. But she's already signing under oath falsely. So she is technically subject to some criminal proceedings. It's just that as a matter of...
But if a woman, and I'm sorry to interrupt, if a woman knows that, I can get away with this. A lot more cases being done regarding this. So if, let's say I'm Wanda, and I'm sorry to bring a name, but that's popped into my head. Let's say, she says, sign this document, and I find out our executive producer, I'm like, whoa. And I take her to court. She's like, nothing happened.
Yeah.
I can do another one.
So she might not be in this scenario criminally prosecuted for the reasons Margie did. It is already illegal, but the state's attorney doesn't normally prosecute perjury cases. But that doesn't mean that you can't get it undone in civil court as far as getting away from your child support. So as I mentioned before, if it's a scenario where there is fraud or forgery involved, you can get that VAP vacated, and then you won't be responsible for the child support. And so it's not like in that scenario you're doomed forever just because she wasn't criminally prosecuted. You'll be able to get out from that child support arrearage if any of it accumulated, and the legal finding of paternity. Fraud, apart from whether or not it's prosecuted, you can still get the effect of it undone in court.
Yeah, I think the issue here is
You're giving me the side eye here. I'm just asking the question.
I have to ask the counter question. So I agree with you that it's really easy to make somebody the legal father, and that seems kind of wrong. But in
other states, like in Indiana, oh, you're wrong. You're going to jail, buddy. Adopt that law here in Illinois. There are so many women that's doing that county that's costing the state and local government money.
I think the budget's a little bit better in Indiana.
Yeah, and I think there's not as many bureaucratic issues with respect to up with this kind of stuff.
But I was going to say that it is really easy to make somebody the legal father, and I think that is a concern. But I think the flip side of that is, without that instrument, people are going to step up and volunteer to pay 18 years plus college expenses. I mean, that's the issue that they were trying to balance, right? Is which way do we tip the scales? They tipped it way too far to it's easy to become the legal father of a child. But we recommend our parentage and child support pro se advice desk to anyone with any questions along these lines, because they are awesome at breaking VAPs.
If you find yourself in court on a non-payment type of issue, if you find yourself wondering how it is you wound up in this situation, or that you got the short end or the wrong end of the stick, and you're in the Daily Center, the clinic has a free advice desk with excellent attorneys who can provide you with advice on the spot and help you begin to unravel and disentangle yourself from the situation, including, as Drew said, vacating the voluntary acknowledgement of paternity.
How can we change that Illinois state law? How can you guys are attorneys? You guys have changed laws. Why not change the child support law?
You got to go a level up. The child support laws in Illinois are driven by the federal funding that comes to the Illinois Department of Public Aid under the 4D program. It's a federal law. So to meet these federal requirements in order to get all of this public aid money. And if Illinois does not follow procedures close enough to the federal requirements, then the public aid system doesn't get this large chunk of funding. So some of these issues, and it's really tangled because it's not just an administrative rule that needs to be changed or a state law that needs to be changed. It has to somehow be untangled from this whole need to fund the public aid, process. But I do think that there are additional protections that Illinois could add. The federal mandate says minimum things that have to be done, right? But Illinois could add, make sure that the people who are allegedly the father of these children are more protected. And I do think that one of the issues is proper service and making sure that a person actually knows that he's being alleged to be the father of a child before a decision gets made on that. And there was a whole period of time in Illinois, more than a decade, where they didn't care who they mailed it to as long as it was ever used as an address. So people who were serving time in prison were allegedly served at their mom's house, and supposedly knew that they had been made the father of a child. So these are issues that the advice desk and other attorneys at the clinic are dealing with. If you can prove that you were not living where you were supposed to have been, then you can get all of that wiped out.
And I guess I would just, tag in here. What Margie just described, I had a client that had almost that exact scenario happen. He was allegedly served at an address that he didn't live at that time, and we were able to prove that that was the case. And because of that, and we attacked it, and were able to undo the entire child support arrearage since that time, which was a substantial amount of money. This is another area actually where our child support and child support and paternity pro se advice desk in the Daily Center handles this exact issue. And I don't want to say all the time because this doesn't happen, all that often. But if you think this is you, this is an area that they, sort of specialize in, and we'd be very happy and interested to hear from you and work with you to do a petition to vacate that. Because bad service at the start of the case can undo everything that happened since then. That can be challenged at any time, even in our scenario, decades later.
Say, for example, the father, he already knows that's not his son.
Mm-hmm.
That's not his daughter. After the conceived.
Right.
How can someone ask for sole custody?
Mm-hmm.
I'm attached. Now I'm like, you're a bad mother anyway. I want that, let me get that.
So you are, in that scenario, the legal father. You have the same right as the mother to seek custody.
Even if the court off the birth certificate or whatever, which was forged.
Okay, so you kind of have to make a choice, I think. There's some really complicated issues of standing. And if you take your name off as the legal parent, do you then still have ask for custody? And it depends on where the child is living at the time and a whole bunch of factors. But the simplest way to look at it is you have to make a choice. You can either not be the child's legal father and probably then not have a role in that child's life. Or you can say, okay, I got suckered into this, but this is my child. I've raised this child. I love this child. And now I want this child to live with me, and I'm going to be the legal father regardless of what biology says. And there are a lot of people who make that choice too.
What are the steps in order to do that?
So if you already signed the voluntary acknowledgement of paternity, or the judge has already decided whether or not that you are the legal father, now you file a petition for allocation of parental responsibilities. Custody. But parental responsibility has two parts: decision making and time with the child. Okay, so if you want to be in charge of making major decisions, that's one aspect of parental responsibility. If you just want to spend scheduled time with the child, that's usually referred to as parenting time. You can ask for either. You can say, I want the child living with me all the time and visit with mom. I want the child with me half the time. I want the child weekends. But you file a petition, then you have to serve mom, and then you go to court, and you can fill in a lot more of these details.
But if your name is off the birth certificate,
If you're not on the birth certificate, but you suspect that you're the father, you can file a petition again for allocation of parental responsibility and ask for a genetic test, a DNA test to be done to prove that you are.
But what if you not in genetic test says you're not, and you want attached?
Okay, and so but you find out you're not the father. That is the more complicated standing issue that Margie mentioned. So most likely, if you're not legally the father, you're going to be out of luck for getting what we used to call custody. As Margie said, the terminology for that has changed. But if the child is residing with you at that time, that can open up standing even for non-parents to ask for custody. So for instance, if the child is living with you and not with mom, and then you find out, you're not biologically the parent, because the child is living with you, potentially you'd have standing to still ask for custody at that point, even as a non-parent. But on the other hand, if the child's not living with you, then most likely you're not going to have standing, because from the court's point of view, you're not biologically the parent, you're not legally the parent, and you don't have contact with the child because the child's not living with you. So it's a complicated issue because there can be questions about where the child is really living, what time, stuff like that. And that would be
what if the child, not to interrupt, but what if the child with you majority of the time, but not technically living with you, but
so if the child's with you the majority of the time, that's probably the area where you can standing to ask for custody. And that'd be an area, again, I would suggest contacting us to try to get an attorney, because that is going to be a difficult case in the normal, just parentage case that most people have. So you'll want to get an attorney to prepare a petition, but that is definitely a scenario where it's at least possible to end up getting custody of the children.
And I think that you want to think ahead of time what evidence you want to gather before you make it known that you're making this claim, because that evidence might suddenly disappear. So that registered the child for school and you're not on the school papers, and you want to ask for custody, and you're going to try to say that the child's with you most of the time, maybe you need to start developing a relationship at the school, so at least the teacher, can give you documentation that you came to the parent-teacher conference, you were there, you were a participant. If you take the child to and from daycare, but you didn't register the child for daycare, you need to start getting like the sign-in sheets or something like that, because you're going to need evidence. Because when you say, I want this child to live with me, mom's suddenly going to say, no way. Like, even if percent of the time, there's going to be a response, and she's going to have, the lease that has the child on the lease. She's going to have the school registration paper. So you have to create your own trail before you say court, because all of a sudden you're going to get a really negative response. You're probably going to expect that child will not see you for a while until you get a court order.
That's 60 minutes, folks. I wanted to thank you so much for coming here, but before I'm going to go, we're going to go down the line to basically say your area expertise and how they can get in contact with you guys.
Sure. So I'm the executive director of the clinic, and you can get in touch with me directly at 312-738-2938, extension 121, and I'll let them talk about intake and their practice areas.
Can you give that number one more time?
Sure, 312-738-2938. Thank you.
My name's Drew Curl. I'm an attorney at the Austin office of the Chicago Legal Clinic, so we're out on the west side. I do primarily family law and criminal records work, so the two areas we talked about today. So if you have a family law issue or a criminal records issue, you can contact me about that, and that is what I do. Of course, can't guarantee that we can take the case, but we evaluate everyone that comes in. The best way to reach us is to call our intake number, which I'm going to give you in a second. And this is actually, you can call this number not just for family law or criminal records, but if you have other types of civil legal issues, just whatever type, call the intake number for any of those. And from there, it'll get assigned out to the proper office. So if it's a family law or criminal records thing, it'll come to my office. But if it's something else and we do it at the clinic, it'll go there. And the number you want to call is 773-731-1762. Again, that's 773-731-1762. That's the intake thing. And all you really have to give is just your contact information and what kind of case you have. So just call up and say, I got a family law problem or I got a criminal records problem. They'll take it from there.
Margie Nielsen, and I'm the Interim Development Director at Chicago Legal Clinic. I also have a caseload of family law and criminal records matters. The best way to reach me is 773-417-9529, 773-417-9529.
You. Well, I'm going to read this, and I want to thank you. Don't be a stranger to the Drive at 5, okay?
Thanks, Roman.
All
Thanks
right.
for having us.
We have a community service announcement, a requirement for the Victims of Violence concert at St. Philip Catholic Church, and Joseph Michael Carr, honor and been killed by violence in the Chicagoland area. On behalf of St. Philip Menere Catholic Church and Joseph Michael McCarr, they are pleased to invite you at the Requiem for the Victims of Violence. I hope I'm just butchering this, of Chicago. They're having a concert this coming up Sunday, October 1st at 4 p.m. located at 2132 East 72nd Street in Chicago. They're opening with a prayer, and Bishop Joseph Perry will do the honors. We will have 2 musical acts, parodies. It's only a suggested price of $20 for a donation, and it's a very nice event. Michael Carr is the sponsor, and he will be on our show in the coming weeks. So again, go out and support the Requiem for Victims of Violence in October 1st at 4 p.m. located at 2132 East 72nd Street in Chicago. Thanks to Earl Winfrey, our executive producer. Wanda, who I mentioned earlier, behind the scenes. Rhea Ray Harris, please get well soon. We miss you here, buddy. She's up next with acreage acquisition and mileage. That's coming up next at 6 p.m. on the Drive at 5. I'll see you next week. Have a good one, everyone.